As Dan said, I'm Reed Junalant, and I'm one of the senior partners at the law firm Ellerby Thompson, Sapp, and Wilson. For those of you not familiar with our firm, we're primarily a labor and employment law firm. We're based in Atlanta, Georgia. We have a substantial public sector practice through which we represent local governments primarily, but some state agencies as well. And most of that representation is in the area of labor and employment related matters, whether that be litigation or administrative proceedings, personnel board, merit board, civil service board type hearings, EEOC, matters before the Wage and Hour Division of the U.S. Department of Labor or other Department of Labor matters, Georgia Department of Labor matters, and then internal proceedings that any given city or county or other local governmental agency or entity may have. We do a lot of what we would consider litigation avoidance type work, a lot of counseling. Those of you that may be with cities that are part of the GRMA liability pool, we handle the GRMA helpline, which hopefully you're familiar with and take advantage of. And so through that helpline and through other interactions with our local government clients, we work hard to try to get involved as early as possible in matters that have the potential to become litigation, to try to keep them from becoming litigation, number one. And number two, if litigation is unavoidable, at least we'll do the best we can to lay a good foundation so that we can get it resolved as quickly as possible and minimize the disruption and costs associated with all of that. So through that process, we've enjoyed a long-term relationship with LGRMS and GMA and GRMA and ACCG and a number of other alphabet soup organizations in the state and nationally. And along with my partner Sharon Morgan, I've been fortunate to take over as a co-chair of our public sector practice group, and we've really enjoyed it a great deal. It's a very rewarding area of practice. So we're delighted to be able to present these webinars with you, although we typically do these live around the state, and we always look forward to that every year. Circumstances being what they are, we're doing this a little differently this year. I think everybody understands that. And hopefully we'll be able to get back out on the road next year and see you in person. So we appreciate your flexibility being with us remotely this time. I'm having a little technical difficulty on my end of things, so I'm going to be relying on Dan to advance the PowerPoint aspect of this as we go forward. So bear with us as I ask him to do that. As Dan said, we'll make the PowerPoint presentation available to you after the presentation. Dan, I didn't mention this to you, I don't think, but we've also got written materials that we prepared, not just for this webinar, but also for the other two. For those of you that have signed up for one or both of the other two presentations, which cover these areas, but also in a little bit more detail and go into some areas that cover some aspects of these topics that we're not able to get to in the time allotted for the webinar. So I will make those available to you as well. We're updating those, and it might take a day or so to get those to you, but we want to make sure that everybody has the most current information available on these topics. Some of the stuff is changing almost daily. And I think also, as Dan said, interactive is best. So interrupt and ask questions as we go forward. Those of you that are able to do that with your microphones, those of you that don't have that available to you, Dan can take your questions and he'll ask them, and we'll try to do it that way. And if it gets to where we are at a point where we may not be able to finish the presentation, we may take some of those questions offline, but for now anyway, let's try to ask them as they come up, because I think that makes for a better presentation for everybody. So Dan, that being said, let's go ahead and jump to what I guess would be slide number 3. And so if you...
and we're there, Reed.
All right, so to make sure we're on the same page, this at the top would say, although the presentation refers to CBD oil, CBD is being marketed in many different forms. So that's just the point there is these materials, the PowerPoint plus the materials that you'll be getting after the presentation, refer to CBD oil just sort of as a catch-all shorthand, but it's not intended to exclude all the other various forms that CBD is being marketed in. And it seems like we add to this list every day. This is a good example of something that has to be updated before we send out the or make available to you the presentation or the handout part of this. But obviously it started as oil, and then there are the vapors that you see the folks that vape are having the CBD made available to them that way. Soaps and bath salts and these bath bombs and the edibles, of course, beverages, teas are popular. It's an additive in the smoothies. There's all sorts of creams and balms and ointments and salves and that sort of thing. Patches for folks that are having arthritic issues or other pain. Capsules, sprays, and lozenges now. That's one of the newer ones from my perspective. Next screen. There are a number of reasons why this is a topical issue, and that is because there's some confusion for various reasons associated with CBD oil and the employee use of it and how it comes up in the workplace. And one of the takeaways here is that there's two very different types of CBD oil, and one is extracted from marijuana. And as you might imagine, that's very different from the type of CBD oil that you can walk into a gas station here in Georgia and buy. That latter type of CBD oil is ostensibly, supposedly, hopefully, extracted from hemp, which is a close cousin to marijuana, but is supposed to be lacking in some of the key characteristics of marijuana. Marijuana and hemp, again, being close cousins, they're both considered to be cannabis. And as cannabis, both plants, both marijuana and hemp, contain compounds that we call cannabinoids. And there's hundreds of different cannabinoids found in both of these plants. The two that are the most important for purposes of our presentation here are the CBD, which is primarily what we're talking about, but also the THC, which I think everyone probably recognizes the initials for the compound which causes the high or the intoxicant that's part of the associated with the marijuana plant. But CBD and THC do have very different properties. Let's go to the next slide. So again, as I just alluded to, THC is the psychoactive compound that produces the high associated with marijuana. It's the intoxicant. Whereas CBD is a non-psychoactive. It has more recently become associated with certain health benefits, which is why we're seeing it everywhere. Now, it's not regulated by the U.S. Food and Drug Administration, and like a lot of healthcare or purported healthcare products that are not regulated by the FDA, you see a never-ending list of purported benefits associated with it. Some of this may be legitimate. I'm not besmirching it. It's just that it just seems to go hand in hand that if it's not FDA regulated, the list of benefits is just is endless. So pain relief and anti-inflammatory type relief is something that's been associated with it for a while. Sleep aid, anticonvulsant, anti-diabetic is more recently something we've been hearing. Anti-anxiety and anti-depression are two aspects of it that are also being billed. Next slide. Now, important distinction between marijuana plants and hemp when it comes to these compounds. Marijuana contains more THC, not surprisingly, than hemp, but hemp does contain a little bit. Hemp contains more CBD than marijuana, but marijuana does contain some CBD. So again, these are cousin plants, and so they do contain the same sort of cannabinoids. It's just that marijuana has a great deal more THC than hemp, and hemp has a great deal more CBD than marijuana. So as a consequence of that, when we're talking about the various products that can be extracted from these two plants, we've got the hemp-based CBD oil, which is what we're seeing, supposedly what we're seeing marketed all over the place, and that you can buy in gas stations in the middle of nowhere. And then we've got the marijuana-based, or sometimes called THC-based CBD oil, which is becoming lawful in certain parts of the country, but not here in Georgia, with one exception we'll talk about in a moment. So THC-based CBD oil. All right, so let me back up and just make the point that CBD oil, when someone talks about CBD oil, an important takeaway is that they're probably talking about the lawful hemp-based CBD oil, but you can't take that for granted. So that is one of the important takeaways, is you need some clarification on that, because technically CBD oil can be extracted from both the hemp plant and the marijuana plant. And if it's extracted from the marijuana plant, there's going to be a great deal of THC in it as well. And when I say a great deal, I mean too much. Wherever you draw that line, it's going to be too much. So there needs to be some clarification based on that. What type of CBD oil are we talking about? So the THC, or marijuana-based CBD oil, remains a Schedule I drug under both federal and Georgia law. So it is still considered to be illegal. Under Georgia law, there's an exception we'll talk about in a moment, but federal law doesn't recognize an exception at all, even where the Georgia exception applies. So the Georgia exception is a little dubious in light of the fact that federal law doesn't recognize one, but we'll talk about that in a moment. So for purposes of most local government employer substance abuse policies, marijuana-based or THC-based CBD oil really isn't any different, isn't qualitatively any different from any other type of marijuana or any other way of ingesting or using marijuana. Okay, so once you've ascertained that somebody's using CBD oil or wants to use CBD oil that is derived from the marijuana plant, I think that you just regard that as any other marijuana derivative for purposes of your substance abuse policy. As a general rule, I think that's a safe way of looking at that.
Reed, got a question here.
Okay.
Is an employee required to tell their employer that they're using CBD oil?
Well, there's no law in place that requires it. The question becomes whether or not you've got a policy in place that requires it. Now, a lot of employers have policies that require that their employees disclose if they're using prescription medications that may impair them or may cause other problems in terms of their abilities to safely perform their duties and responsibilities. But CBD oil is not something that's prescribed, so it would not. I don't think I've ever seen a policy that would actually cover CBD oil. So there's no law that requires it, and there's probably no policy that is in existence right now that any local government employer, at least that I'm familiar with, has in place that would require it, unless it's been recently enacted. So you can impose that requirement, and it might actually be a good idea. That's something we're going to talk a little bit about towards the end of the presentation. but no, in the absence of a policy requiring it, there is no independent obligation on behalf of the employee to disclose that information.
Here's another question related to that. Does questioning the employee violate HIPAA if used for medical use?
No. The employee, all right, so the only way that all right, I think that question must assume that we're talking about the marijuana-based CBD oil. Is that correct?
Not by that.
I'm sorry.
Asking the general question regarding things.
No, I think that no. I'm just going to say no. Whether it's the hemp-based or whether it's the marijuana-based CBD oil that certain employees can use pursuant to a very narrow exception under Georgia law, I think that the employer is allowed to have a discussion with the employees about the underlying condition and whether or not there's an alternative. We would consider that to be part of the reasonable accommodation interactive process under the ADA. And again, that's something I'll talk about a little bit more detail as we get towards the end of the presentation. So let me move on, and we'll talk about that in more detail in a few minutes. So Dan, let me make sure we're on the same slide here. Does yours say summary at the top? And if not,
yes. Yep.
All right. So this is really just to sum up, just that some points already made, that the hemp-based CBD oil is lawful under federal law. Well, hang on one second. Yeah. Okay. The hemp-based CBD oil is lawful under federal law and Georgia law, provided that it has no more than 0.3% of THC. So what this recognizes is that it's likely impossible to distill CBD oil from hemp without there being some trace amounts of THC. And the amount of THC that the government is willing to tolerate is 0.3 of 1%. In other words, less than 1%, less than half of 1%, less than a third of 1%. It's 0.3%. So that's just a tiny, tiny amount of THC. And anything above that amount is actually going to be in violation of federal law. That's actually a very new amendment to the federal law that made even hemp-based CBD oil a Schedule I drug. This farm bill that was passed 2 or 3 years ago allows for the production and sale of hemp-based CBD oil and similar products, provided it meets the standard of less than 0.3% of THC. And then Georgia's criminal law, drug law, tracks the federal law. And so when the federal law created that exemption for that tiny amount of THC, the Georgia law sort of automatically went along with that. Now, marijuana-based or THC-based CBD oil, it remains completely unlawful under federal law, no matter what the percentage is. And it also remains unlawful under Georgia law unless it falls within this exception that is covered by this medical marijuana law that was passed a few years ago and is amended every other year or so, called Haley's Hope Act. And I think most of y'all are probably familiar with it, with Haley's Hope Act. It's, as I said, it's a medical marijuana-based statute, and it does get amended and expanded a little bit every couple of years. And it's worth looking at when it was first passed, the medical conditions and diseases that it covered were so extreme that there was really no chance that anybody who was suffering from those conditions would ever be actually working anywhere. And so even though the legislature was very careful to put in the law that employers weren't required to allow employees to work and use medical marijuana, as a practical matter, there was no way that was going to happen anyway, based on the limited number of diseases that were covered and how extreme they were. But the act is designed to be expanded upon as committees look into the different medical conditions and diseases that might actually be helped by some of this treatment through THC. And as a result, there have been a couple of expansions of it. And so now we probably do have some individuals that could be in the workplace with some of these diseases or medical conditions. And consequently, while it's still unlikely that it's going to be a common issue, it is possible now that some of the individuals that qualify for this medical marijuana exemption under Haley's Hope Act may be in the workplace, and we'll have to deal with that situation. But let's see, Dan, go to the next slide that says Haley's Hope Act permits individuals.
Yep, there you go.
All right, so you see where it says permits individuals suffering from certain serious diseases to possess and use up to 20 fluid ounces of what they call in the statute, low THC oil. And that's defined as containing no more than 5% THC. Now, compare that to what the federal law under the Farm Act from 2018 allows in hemp-based CBD oil. They, again, as I said, they recognize that when you're distilling CBD oil from hemp, you're going to invariably have trace amounts of THC in there, and the federal government, and by extension, the state government, is going to allow 0.3 of 1%. So that's less than a third of 1% is going to be allowed. And here with Haley's Hope Act, we're allowing a full 5% of THC, and that's still considered low THC oil. So that gives you a good frame of reference for how little THC the federal government is tolerating in the hemp-based CBD oil, because the state of Georgia with Haley's Hope Act is only tolerating 5% THC oil with folks with these really awful medical conditions and diseases. But interestingly, this Haley's Hope Act, it really only affects the criminal law of Georgia. In other words, it protects individuals who qualify for medical marijuana use, this low THC oil, from being prosecuted under Georgia's drug laws. It doesn't, as I said earlier, it doesn't provide any employment protection. It doesn't give you the right to work in the private or public sector workplace and use this product. It even folks have pointed out it creates sort of a conundrum because it doesn't even allow you legally to purchase it. It doesn't allow anyone in the state to produce it or to sell it. So I think it's probably safe to say that folks are kind of looking the other way, or law enforcement is looking the other way in terms of how people who are qualified to use medical marijuana under this law are actually getting it. But there are some gaping holes in the statute in terms of how they're supposed to get it. But there's a very complex process associated with it. It's not by prescription, which is different from what you see in other states where medical marijuana is prescribed. You do have to be referred by a physician, and it's not one of these situations where you can just go see a physician that you've never seen before, and he listens to you and decides, okay, I'll approve that, and then you can go get your medical marijuana card. It's not like that at all. It's got to be somebody that you've had a long term bona fide patient-physician relationship with, who's been treating you for the actual condition or disease that the physician determines warrants the medical marijuana or the THC oil. And then there's an application process through the state, and you obtain a registration card, and through that registration card, however you end up acquiring your THC oil, as long as you've got that registration card with you, if you're caught with the THC oil and you can show the registration card, then you won't be arrested. And that's really the extent of it. You've got to have, no more than the 20 fluid ounces. It's got to be in proper. It's got to be in a proper container that's properly marked, and all of this. And so there are a few other technical requirements associated with it. And this just shows how loath Georgia is to get into this whole marijuana thing. They're doing it because they recognize that there is some genuine value to THC as a medical treatment for people that have some of these really just terrible diseases and medical conditions. But they're also very worried about it being abused, as it's clearly being abused in other states. All right, let's go to the next slide, Dan. Not to turn this into a Haley's Hope Act presentation, but I just wanted to give you all an idea of the current list of conditions that are covered by Haley's Hope Act. This is an expanded list from what was previously in place there. You see it starts off with cancer, and it contains the original language about end stage or wasting illness. And, this is the sort of situation where you can't really envision somebody being in the workplace in that, with that stage of cancer. Let's go on to the next slide. And then we've got folks that have PTSD, if you see the last point there. And so there are, that can be very debilitating, obviously, but there are folks with PTSD who are able to and do function in the workplace. And so now that conditions such as that are being added to the list, I think it's going to be something that local government employers and private sector employers are going to encounter more and more often. And so some decisions are going to have to be made as to whether or not it's going to be tolerated, because again, the law does not require employers in the public or private sector to make exceptions under their substance abuse policies to allow employees to use this medical marijuana, this low THC oil, even if they qualify under the law. You're going to have to take a lot of things into consideration, including what the duties and responsibilities of the employee are, and the risk of harm if they are impaired, and that sort of thing. So a lot is going to have to be taken into consideration if and when you're presented with that situation. All right. Let's go to the next slide. Actually, let's skip beyond that, because I think I've covered that issue, and go to the one that says, thus, all right, so even taking Haley's Hope Act into account for purposes of most substance abuse policies that local government employers have in place, THC-based CBD oil or marijuana-based CBD oil is not going to be treated any differently from other types of marijuana or other forms of consuming it or using it, whether it's the old-fashioned smoking it or eating it or whatever else people are doing with marijuana these days. The things they're coming up with are amazing. All On the other hand, what we're finding is that few policies were drafted with hemp-based CBD oil in mind. I realize, in looking back, that the lobbies, the hemp lobbies, were very active in trying to get some exceptions made for years, if not decades. And so this probably was somewhat predictable, but it wasn't something that I was following. So I was a little surprised when the Farm Bill was passed in 2018, given how strongly the federal government had historically drawn, such a tight line on the issue of marijuana. There was a lot of lip service given during the Obama administration to legalizing marijuana, or at the very least, classifying it lower than as a Schedule I drug, but that never actually happened. The most that happened during the Obama administration with regard to the various states that started recognizing the medicinal value of THC in marijuana was that he sort of instructed, but not even formally, not even through an executive order, but just sort of informally, stated that the Department of Justice, they had more important things to prosecute than people that were, using medical marijuana for legitimate medical reasons. And so that was the closest he came to providing any assurances that this was not going to be something that the federal government was going to spend a lot of resources prosecuting. But he, interestingly enough, it never came down off of the Schedule I drug list, and it's still there. But now we have this amendment that under this 2018 Farm Bill that does allow for hemp-based CBD oil to be produced and marketed and sold and used, possessed. I mean, it's a across the board exemption, unlike Haley's Hope Act, which allows for use but doesn't provide a whole lot of guidance as to how you're going to obtain it. Doesn't provide any protection to the people that manufacture it and sell it and distribute it. The federal government, through this Farm Bill, covered all those bases with the hemp-based CBD oil, provided it meets that standard of being under 0.3% of THC. So, as I said, that while I think the fact that that folks have gotten very creative in what they're doing with marijuana really doesn't change too much from our private and public sector client standpoint, because their substance abuse policies, for the most part, are probably okay, already covering various marijuana derivatives, and probably don't need to be amended to cover those. But very few of them were drafted with the idea that this hemp-based CBD oil would be lawful. And again, because it's still a relatively new development there. Let's go to the next slide.
So before you go on, Reed, got a couple questions. Under the current medical marijuana law, the Georgia Department of Public Health can issue a low THC oil registry card to certain people that will protect them from arrest and prosecution if they found possessing the oil. Currently, there are only a few specific disease eligible to apply on the registry. Physicians have determined that they qualify for the low THC oil, and have registry cards should inform human resources. We added this under our drug section. Opinion?
Well, I do think that's appropriate. Again, one of the points that we'll cover towards the end here is that the time for this discussion to take place, in our opinion, with these employees is before they test positive. Once they've submitted to a drug test, and the test results have come back, that's not the ideal time to have this conversation, nor is it a good time to have the conversation when their name has been drawn. If they're, if they happen to be in a position that's subject to random testing, and their name is drawn, for that purpose, that's not a good time to find out about it for the first time. And certainly if they're not subject to random testing and there's some condition, whether they're in an accident and you have post-accident testing, or there's just something, some suspicion-based testing because of, something that a supervisor detects in the way that they're conducting themselves or appear. These are all, not the ideal time for this information to be discussed. So I believe that is an appropriate policy to implement. And, obviously you're going to want to be very discreet, maintain confidences with it, because if they do have a registry card, then that means that they are almost certainly going to have a condition that's going to qualify as a disability. So we have, confidentiality obligations there. But at the same time, we've got obligations to engage in the interactive process. It's not a foregone conclusion that using the low THC oil is the only option for them. It's not, as I said earlier, there's nothing under the law, whether we're talking about Haley's Hope Act or we're talking about the ADA, there's no law that requires that the employer allow the use of low THC oil, even for legitimate medical purposes, by employees. And so it is not a reasonable accommodation. It's not part of your reasonable accommodation obligation. Frankly, I'm a little worried about the precedent you might be setting if you actually treat it as a reasonable accommodation under the ADA, because at that point you may have others that want to use it as a reasonable accommodation where they have situations that where they don't qualify for it under Haley's Hope Act, and it's a slippery slope type situation. So it is and then there's that whole issue of the fact that it remains illegal under federal law. I mean, the state of Georgia does not have, cannot make something legal under federal law. And, they're perfectly within their right to make something legal under Georgia law, but as long as it remains unlawful under federal law, and as long as the key statutes that we're dealing with here, HIPAA, ADA, these are federal statutes, I think that becomes very relevant that federal law still treats this as a Schedule I narcotic, and so that factors into that process. So I think that that's a prudent policy, and as I said before, it's not in anyone's interest to find out later in the process that for the first time that someone's using this this product. I mean, I feel the same way about the hemp-based CBD oil for reasons that we'll talk about in a moment. But
I've got a couple more questions, and then I probably should go on with the presentation. Our person that does drug testing said all CBD oils are made differently and wouldn't risk it if to random test at work. Can you trust that if you used hemp-based oil lotions that it's less than 3% and won't be detected on the drug test as a positive to risk losing your job?
No, and that is a big part of it. In fact, why don't you go to the slide that says, can local government employers?
There we go, right there.
Okay. So it says, can local government employers prohibit their employees from using any form of CBD oil? And so, and we'll talk a little bit about the explanation there. But let me address the question, and it's talked about in that last bullet point there. So I'll just read it. It says, on the other hand, due to the current quality control issues, and again, remember, this is not an FDA regulated product. So due to current quality control issues and the lack of regulation, as much as 20% of the commercially available CBD oil tested contains more than 0.3% THC and is therefore unlawful under federal and state law. So this is just random testing. This was done in 2019, a little over a year ago. I don't know if they've gotten better since then. But what happened was, and this is not unusual, is when this farm bill passed, just hundreds at least, if not thousands of people, companies, wanted to take advantage of it, and so they just, they jumped into this market as quickly as they could. And there are just tremendous quality control issues, and they all say that they have different verbiage, but they either say that there's no THC, or they might specifically reference the under 0.3%. Or whatever it is. They've got to put something on there to show that it's legal. But the fact of the matter is that they're not they're not using facilities that are sophisticated enough to test whether or not they actually have got a batch of hemp that is low THC. I mean, I'm not a botanist, but from what I understand, these plants being very similar to one another, you often you can actually have a batch of hemp, batch being probably not the right word, but you can have a hemp plant that could have an unusually higher amount of THC in it than another, and they don't have the process in place to identify that and toss it. So, and I think that was probably the point that the question was referring to, which is that you just don't know what you're getting. And it's really a shame to think that you may not find out until your test result comes back that the CBD oil that somebody recommended to you just to rub on your tennis elbow actually had a good bit more THC in it than it was supposed to and than it was advertised to have. And as a result, you tested positive, and then you're bringing your bottle in trying to convince whoever it is you're trying to convince, the medical review officer, depending on how your system is set up, or HR or your manager or your city manager, that's what you were using. But that's that's part of the problem. You're making your case after the fact, and that's the least credible time to be having that conversation. So, and incidentally, I'll add that the current position of the Department of Transportation with regard to the mandatory testing of individuals that have commercial driver's licenses is that you cannot make that distinction. If they test positive, they test positive. We're not going to get into splitting hairs as to whether it came from a bad batch of hemp-based CBD oil. So this is the message that needs to be conveyed to employees. We created an FAQ sheet, which I'll go ahead and update and include with the packet that I'll send you, Dan, that you can make available to our friends here, that they can in turn make available to their employees if they want, that lets them know that what these risks are. Because at the end of the day, unless you're going to ban the CBD products as an employer, then in my mind, there's really two ways that an employer should approach this: either ban it outright, and there's some problems associated with that, which I'll mention in a second, or educate your employees and let them know that the way things stand presently, you are using it at your own risk, and you're going to have a tremendous amount of confidence in the company that produces the hemp-based CBD oil that you're using, because if you test positive, you test positive, and that's that. You know, whatever the normal consequences are under your substance use policy, you know, that's what's going to happen here. So, you know, the FAQs could be used for that latter purpose. Does that answer that question?
It does.
All right. Well, let me go back towards the top of that slide there. That question that I posed at the top of the slide is whether local government employers can prohibit their employees from using any form of CBD oil. And so I make 2 points under there. And you know, the first point is I kind of go back to the marijuana issue, and the fact that remains unlawful and has been unlawful for decades, and it's unquestionably causes impairment. Then, you know, the court, and this is something that's gone all the way to the U.S. Supreme Court, and the standards are very well established by now. The Supreme Court has recognized that local government employers have a compelling interest in prohibiting its use by employees. And, you know, importantly, you know, testing for marijuana in any substance, any prohibited substance, is considered a search. You know, I often point out that, you know, those of us that have human resources related responsibilities, we've got a lot of challenges, you know, both at the state and the federal level. In Georgia, we don't have quite as much, you know, state regulation as other states have, but, you know, the federal government's been very active in imposing a lot of regulation on the employer-employee relationship. So we've got a lot on our plate. But in the public sector in particular, we've not only are we subject to pretty much everything that our colleagues in the private sector are subject to, with a few exceptions, but we're also subject to the restrictions imposed on us by the state and federal constitutions, which apply in various contexts in the you know, in the employment arena. And one way that the Fourth Amendment applies, that's normally associated with arrests and that sort of thing. But, you know, it protects citizens from governmental searches and seizures. And, you know, urinalysis and other drug tests are considered to be a form of search. And so they're permitted so long as they're reasonable. And so the Supreme Court has decided several decades ago that it's reasonable for a local government to conduct a search in the form of a urinalysis or other you know, form of drug tests of its employees under, you know, depending on what the employees' duties and responsibilities are. So that's how we've got this dichotomy now, that if they're involved in law enforcement or they have other safety sensitive type duties and responsibilities, you know, I think public safety generally probably qualifies. We know that the Department of Transportation has stepped in and decided that the folks that operate vehicles that require commercial driver's licenses are in there as well. So we've got the random testing for those types of employees. And then while we can't randomly test employees that don't fall into those categories, we are allowed to test them if we can identify certain things that are going on with them. Maybe it's a post-accident, maybe it's the smell of marijuana, or they're just, you know, we can tick a few other boxes in terms of how they're acting or speaking or how their eyes look or whatever it might be. And so it's that entire process that allows us to conduct a search under those circumstances, because the compelling interest that's associated with the impairment that marijuana unquestionably causes, marijuana use. Now, with genuine hemp-based CBD oil, genuine meaning that it's got less than 0.3 of 1% of THC in it, then presumably, I mean, there is no impairment associated with it. It's there may or may not be any health benefits associated with it. There are folks that think there are, and the jury's sort of out on all of that. But most people agree that it doesn't. If it has less than 0.3 of 1% of THC, most folks agree that it does not cause impairment. And as a result of that, the local government employer's interest in prohibiting its use and therefore testing for it is much lower than it would be for marijuana or any other substance that causes impairment. So ultimately, I do believe that it's going to be difficult for local government employers to justify an outright ban on hemp-based CBD use. But the reason I qualify that by saying ultimately is because of the last point, which I covered out of order, which is that right now, we're not in that situation, because right now we can't trust the hemp-based CBD oil. Right now, the situation is such that there's a meaningful amount of hemp-based CBD oil that, I mean, 1 in 5, if that 20% is accurate, then 1 in 5 that you could buy over the counter has got an excessive amount of THC in it, which the federal government feels like is enough to potentially cause impairment. And so, so long as that remains the situation, I think that local government employers are in a reasonably compelling position to ban the use of CBD products, whether they're hemp-based or marijuana-based. So the only point I'm making is that as quality control issues come to bear, and the companies that aren't producing reliably safe CBD or hemp-based CBD products are forced out of business, and the companies that are devoting significant resources to producing reliably lawful quantities of hemp-based CBD oil, start dominating the market. I think at that point, local government employers may need to revisit whether or not they want to continue precluding employees from using hemp-based CBD oil and similar products completely, and just pass the risk on to them that they're using a quality product that's not likely to lead to a positive test result. But the way things stand right now, I think a local government employer probably could lawfully preclude the use of all forms of CBD oil based on the uncertainty associated with the quality of the hemp-based products that are out there right now.
Very good.
All right. Well, let's go to the next slide. And this is a little bit of a departure. I think one issue that we see, which really has little to do with the hemp-based CBD oil, but given that it seems like every year another state gets added to the list of states where you can go and under some circumstance at least meet some low threshold for qualifying for medicinal marijuana, if not recreational marijuana. Folks are going to these other states and they're trying it, and then they're coming back to Georgia after their vacation. Hopefully they're not doing this on business trips and whatnot, but in any case, the question becomes what happens when they come back and they test positive for marijuana or THC in their system, and they say, well, I was in California, I was in Colorado, it's legal there. Surely you're not going to penalize me for doing something that was legal in Colorado just because it's not legal here in Georgia. And well, under those circumstances, it really doesn't matter where it was done. I mean, the question is, particularly with regard to a substance abuse policy that's based on positive test results. If you've got a positive test result, I've yet to see a policy that asks where it occurred, and usually that's an irrelevant consideration. Now, what we do see sometimes are policies that are that aren't based so much on positive test results. They're more of kind of an old-fashioned type policy that precludes use of marijuana and marijuana derivatives and other unlawful substances, period. You can get into some kind of a little bit of a legal argument over whether, well, what is a legal substance, because it was legal where I used it. I think that right now that argument is not a winning argument for the employees because of the fact that the federal government still defines marijuana and marijuana derivatives as Schedule I unlawful substance. That's a little unusual. Would not have predicted that at this point, but that's still the case. So I think as long as that remains the case, that is still going to be an argument that local government employers are going to win, but it's less compelling than the positive test result, because the positive test result is just a little bit easier for the courts to get their hands around. So I don't know if any of you have some of what I call the more old-fashioned type policies that focus less on whether it's in your system and more on whether you're using it. I think I sort of prefer the hybrid, the one that is a combination of both, that precludes use, possession, sale, purchase, and that sort of thing, but also requires random testing for those employees that are subject to it, and suspicion-based testing under those circumstances and post-accident where that's appropriate as well. But here again, this is a sort of a change from even 5 years ago. There's so many more places where employees can go, and sometimes, I mean, there are even states that are within driving distance where employees can go and do this, and they don't always get that. Just because it's legal in that state doesn't mean they can't come back and test positive and be in a lot of trouble when they get home. So let's go to the next slide here, which actually is my last slide. We have under certain circumstances, an employee's announced desire, and we've covered this a little bit, but announced desire to treat a medical condition with a hemp-based CBD oil may implicate the local government employer's obligations under the ADA. So what happens is, I mean, again, as we've mentioned, it's best to require that employees that if you're not prohibiting the use of CBD oil across the board, you make the FAQs available to them, or otherwise educate them as to the risks associated with using hemp-based CBD oil, and require that they speak to someone about it if they're inclined to use it. And we would treat that as a request for a reasonable accommodation. Have that conversation, find out what it is that they're trying to treat with it, and see if there is an alternative that might be available for it. There might be some adjustment that you could make to the person's job that would eliminate or moot out the need to take to use the CBD oil altogether. So here again, allowing the use of the CBD oil is not necessarily a reasonable accommodation under the current state of the law, and so there may be some other way to accommodate that. They don't have to use any magic words to trigger your obligation as an employer to engage in this interactive process. So just letting you know that they're planning on treating something with CBD oil is enough to trigger that obligation on your part to inquire into what they're trying to accomplish. And if it's your preference that they not use the hemp-based CBD oil, then go ahead and get that inquiry going and figure out what, if anything, there might be that they could do or that you might be able to do for them that's an alternative to the CBD oil that could address that particular problem. As we've talked about in ADA specific presentations, the employee's preferred choice of accommodations is definitely something you want to take into consideration, but it's not determinative. The ADA does not give them the right to pick their accommodation. You want to hear what they think would work best, but ultimately the decision is up to the employer. And as we've said before, making an exception to your substance abuse policy is not, under the present state of the law, is not a reasonable accommodation. All right. So, and as I said, I think this is a very important point, that the DOT currently has taken the position that if someone tests positive for THC, someone's being tested pursuant to the DOT regulations because they have a commercial driver's license, CDL. The DOT regs do not allow us to get into an inquiry of whether it may have just been because they were using a bad batch of hemp-based CBD oil. All they're concerned with is the positive test result, and so I think employers are permitted to take their lead from the Department of Transportation there and adopt a similar approach. As long as the federal government is taking that approach, that's a pretty safe approach for us to take as well, if you're so inclined. So that's all I have. I've taken us right up past the 3 o'clock mark, but I'm happy to take questions. I can take them offline, whatever works best.
Got a few questions, or a couple here.
All right.
Our person, I guess I read that one. If you find out a new applicant uses the oil and you decide not to hire them based on that, do you have to tell them?
Well,
if you're hiring somebody and you find out that they are using the oil and you don't hire them, do you have to tell them the reason you're not hiring them?
Well, I guess it depends on how you find out. I mean, if you find out through a pre-employment drug test, then I would say yes. But if you find out through some background check of some type, or I'm not sure what the other way would be, but if you find out through some other way, then I would say no, not necessarily.
Okay.
It's
not questions or comments for Reed. Thank you so very, very much, Reed. I really appreciate it. It was very interesting to learn about CBD oil. I was unaware of all those particular things. There's a thank you. Our packages of CBD products marked as to whether it is delivered from hemp or other. You know,
yes.
So they are labeled that way.
Yeah, they wouldn't be allowed in the state.
But you're saying they might be labeled that way, but they might not be that way.
Well, the marijuana or THC based hemp oil, I'm sorry, the marijuana or CD or THC based oil is a lot more expensive.
Yeah, I would assume so. Here's another question. Is vaping allowed in a government building?
Is vaping allowed in a government building? I don't believe so. I think they treat it like cigarette smoke.
Okay.
I know they do on the FAA does for airline purposes.
Very good. Thank you so much, Reed. Thank you all of you that participated. Again, I'll be sending out the presentation along with the recording. I look forward to you participating in tomorrow's webinar, and we'll have one also on Thursday. So thank you so much, Reed. Have a great rest of the day.
You as well, Dan. Thank you. And I'll be sending you the handout materials shortly.
Excellent. Thank you.
All right. Bye-bye, everybody.